Hi guys, welcome back to Nairobi Legal Insights. In our video today, we're going to be focusing on mergers and acquisitions and specifically pointing out some of the most important key sections and concepts you should know in under 20 minutes. In this video, we set out to achieve 6 key things, and as you can see, we're going to be looking at the definition of a merger, the different types of mergers, and then we're going to look at the methods of mergers. And I'm also going to highlight some of the most critical sections in the Competition Act of Kenya 2010. This is the act that regulates mergers in Kenya. And towards the end of this video, I'm going to be providing guidelines that you should be able to read to appreciate how mergers operate in the Kenyan context. So these are the 6 things we should be able to have understood by the end of this particular video. Starting with the definition of what a merger is in the Kenyan context, we have section 41 of the Competition Act of Kenya that defines what a merger is. And in simple terms, we have one undertaking. It could be a company establishing control over another company, and this control could be direct or indirect, in the sense that some companies could opt to go directly to the target company and express the interest to actually merge with that company. Or a company could also opt to use what we call a hostile takeover, where a company A goes ahead to buy shares that belong to shareholders of company B in the market. So by buying all the shares directly from shareholders, then you indirectly actually gaining control over the target company. But then we're going to be looking at all the different types of mergers and methods so that we appreciate how these things take place. So to begin with, the definition can be found under section 41 of the Competition Act of Kenya 2010. Now, before we even go any further, I want us to first understand the reasons why companies merge. Now, what would be the interest of one company merging with another? Remember that this is business, and for someone, or rather a company, to express interest in another, there has to be a reason. And some of these reasons are based on efficiency. Let's say company A is in the manufacturing business and company B is also doing manufacturing, but then company B has great human resource capital in terms of expertise of employees. They have a good production line. They have established a strong network with suppliers and maybe where they buy their raw materials. So basically the company is well known within the market. And so company A will opt to take over this other company for purposes of increasing its efficiency in terms of the business, in terms of the kind of business it is operating in. The other reason could be entering markets. So again, we may have a target company. Now, I'm going to be using these terms because they're technical. Specifically, this is the language we use when we are talking about mergers and acquisitions. So a target company is the company you're interested in, and the bidder is a company coming after that target company. So if a company wants to enter the Kenyan market and that specific company, let's call it company A, doesn't want to start from scratch, and that company A is maybe in the business of manufacturing dry cells. So instead of starting from scratch, it could opt to look at another company in Kenya that does the same kind of business, and then merge with that company so that entry into the market becomes easier. Because remember, the company that is already established in Kenya has a customer base. It has loyalty from customers, it is well known, and it has established itself already within the Kenyan market. So by merging with that company, then the company that is interested, in this case the bidder company taking over this target company, will find its work easier as far as entering a new market is concerned. And then we have growing business size. Assuming company A has the financial muscle, it has the money, and it intends to expand its business, it can opt to look for another company in the same line of business so that they can merge together with a goal of actually expanding company A's business, because that is its interest, growing in size. And again, when we go further into mergers, we have something we call horizontal and vertical mergers. And specifically, we're going to also be detailing and analyzing the different types of mergers. But as you can see from your screen, when we talk about horizontal merger, here the merger is between two or more undertakings producing or offering substantially similar goods or services in the relevant market. Now, this is a keyword, relevant market. We have two or more companies producing substantially similar goods in the relevant market. Remember, language is very key as far as mergers are concerned, and I will refer you to Section 4 of the Competition Act of Kenya. Read it to understand the language that is used there. When we talk about a relevant market, or when we talk about a competitor, or when we talk about competition, what does it mean in the context of mergers? So anyway, coming back to this definition as you can see it, here we have these two companies, they're coming together, producing substantially similar goods in the relevant market, and they're at the same level of business. Now, just to give you an example here, it could be a horizontal merger, could be a merger between two manufacturers. Maybe company A and B manufacture Blue Band, then they come together. You see, they're in the same line of business. The market is the same for Blue Band, so that is a horizontal merger. And then mergers, also one thing you need to take note of is that mergers should not be permitted to create or enhance market power. These are some of the reasons that the CAK, the Competition Authority of Kenya, will look at before either approving, declining, or approving with conditions for merger to actually occur. And we're going to be looking at this, as you can see already, under Section 46. So mergers that are likely to prevent or lessen competition are likely to be declined by the Competition Authority of Kenya. And as you can see from this point verbative, if a merger is intended to lessen competition in a relevant market, then that will be one of the reasons that CAK will take into consideration to either decline or approve such a merger. So pay close attention to Section 46(2)(a) of the Competition Act of Kenya, because it outlines some of those considerations that are very critical when it comes to mergers. So the other thing we need to appreciate is that, remember I've said for horizontal mergers, they're in the same line of business, offering goods into the same relevant market. So horizontal mergers will at all times need approval of the Competition Authority of Kenya because it has to assess whether this specific merger is going to lessen competition. So the other thing, again, we need to pay close attention to is that some of the considerations that you're going to be finding under Section 46 are that the assessment of whether a merger should be approved or not will be based on whether it is going to create a barrier to entry. Barrier to entry here, what I mean is that maybe if company A and B merge together, then they will make it so difficult for another company to come and enter into that specific market and start producing the same goods. And then also company A and B could have come together to merge to create a coordinated effect. Maybe they want to have the market power. They want to have the dominance in the market. They want to control prices. So all those things are looked at to assess whether this specific company is viable to be accepted to merge with another company. Now, this section, I will be breaking it down further in the course of this video. But as far as this is concerned, it was more of an introduction so that you start piecing things together. Now, having discussed what a horizontal merger is, I want us now to look at vertical mergers. And when we talk about a vertical merger, it involves undertakings operating at different levels of the supply chain. Now, different levels of the supply chain. In the previous merger, we talked about two companies being at the same level in the sense that they're producing substantially similar goods for a relevant market. Here, as far as vertical mergers are concerned, we are talking about a situation where companies are operating at different levels of the supply chain. And I'm going to give a very interesting example here. Now, assuming that we have petrol stations here, This could be rubies and shell. And then at the top here, we have raw materials. These are raw materials that are used to refine the fuel that these companies then use, and it is later sold to the customers directly. Now, assuming we have raw materials here, and then we have petrol stations at the bottom, then at the center here, we just have a single refinery. This is the refinery that purifies these raw materials to make the petrol, and the petrol is distributed to the different petrol stations at the end here. So I'm establishing a connection for you to understand how a vertical merger operates as far as two companies being at different levels of the supply chain are concerned. So taking you back to the first example so that you appreciate the difference, in a horizontal merger, the test is we are looking at one key concept here. You'll be asking yourself a question: are the companies competing with each other at the same level? If they are, then that is a horizontal merger. So it could be rubies and shell. They are all in the business of selling petrol. It could be Facebook and Instagram. They are all in the business of online texting, exchanging messages. Similarities are there, sharing pictures. Now, on the contrary, when we talk about a vertical merger, the test will be here. You'll be asking yourself, does one supply the other? It's about supply. It's about being at different levels of the supply chain. So in this case, we have one refinery supplying to different petrol stations. And so to make this clear again, if one company out of these petrol stations, we have Shell, Total, Rubies, if Rubies decided to come and actually purchase this single refinery that purifies petrol for the rest of the petrol stations, now that will raise a suspicion, because as you can see, it is a vertical merger in the sense that these two undertakings are operating at different levels of the supply chain. So this will raise suspicion, and this will be a vertical merger, and so there will be need for approval for such a merger to happen, because if Rubies takes over the single refinery, then it's likely going to control the market, the prices, and everything. So it's going to control even how much fuel other petrol stations are able to receive from this single refinery that Rubies chooses to merge with. So with this explanation, I hope you've understood what a vertical merger is. But basically, these two tests help you to distinguish between a vertical merger and a horizontal merger. Now, having understood vertical and horizontal mergers, I want us to draw attention to the different ways in which mergers can happen. So the first way is what we call a takeover. Now, this takeover could either be hostile or not, and it could be done in whole or part. And I want us to first appreciate what a hostile takeover means. So we may have a situation using an example of company A and company B. So company A is the acquirer, or it is the bidder company, and company B is the target. Remember, language is very critical in mergers and acquisitions. So company A could opt to take over the entire company B, or it could buy over 50% shares of company B. So this is a hostile takeover. You know, with 50% shares, you basically own half of the company. And in practice, what happens is that we may have a situation whereby company A approaches company B and express interest to actually take over company B, or buy shares, purchase shares or stock in company B. Now, if the management of company B declines to that proposal, company A could opt for hostile takeover, in the sense that, assuming this is a public company. Now, public companies have shareholders who actually, these shareholders are the people who own that company because they've invested in their money. They have shares in that company. So in order to gain control of company B by company A through a hostile takeover, what company A could decide is go directly in the market and start purchasing off shares of company B from its shareholders. So company A will be approaching the shareholders of company B directly in the market and buying off shares in the market And this scenario means that company A would have bypassed the management of company B and gone straight to the shareholders in the market. Remember, shares are freely transferable. It's free property that you can actually sell to anyone. It's a willing buyer, willing seller. Unless there are certain clauses in the Articles of Association of a company that provide for preemptive rights. But then we will be going into the details of that later when we discuss about shares. So basically, I hope now you understand what a hostile takeover is. And like I said earlier, also company A could opt to pick up part of company B. So this example clearly explains what is involved in a hostile takeover. Now, there's sometimes a confusion that people might have when we talk about a merger, when we talk about an acquisition. But in this specific explanation on this screen, I have used an illustration here. When we talk about a merger, we may have company X plus company Y. When they merge together, they create a new entity called company Z. You can see the red color, blue color, and the green. So this is company X, Y coming together, and then they form one single company, which is company Z. And then in an acquisition, we have a situation whereby company X and company Y merge together, and they form company X. Company X is now the larger company. As you can see here, in the first example, we had X plus Y giving us Z. In the second one, which is now an acquisition, we have X plus Y giving us X, meaning that X has taken over Y and retained its personality and legal standing as the company that has acquired company Y. So that is the distinction between a merger and an acquisition using these two simple illustrations. Similarly, we may have a situation where we have company X acquiring company Y, and then what is going to be formed afterwards is company X plus company Y, but in this case, company Y will cease to be a legal entity. So the only legal entity we have in this particular example is company X, which remains standing. So you need to appreciate, by just looking at these color coordinates I've used, you need to appreciate what is a merger and what is an acquisition, and what company remains standing after the merger has happened. Of course, at a high level specialization in mergers and acquisitions, you start to talk about other different types of mergers, but mostly from an international perspective. But for the Kenyan perspective and the Competition Act of Kenya, let us focus on some of these examples for examination or rather test purposes if someone is trying to understand these concepts. So the other way in which mergers can happen is through a JVA, a joint venture. We may have joint ventures, and when we have joint venture agreements, we may have a situation whereby, or rather this is a situation whereby we have more than one entity, being formed. So as you can see on your screen, what I'm talking about here, a joint venture agreement results into more than one entity being formed than the two entities that started such an agreement. So using an example here, when we have company X coming together with company Y to form company X, Y, and Z. Now, in this specific situation, like I said, more entities are formed than they were before at the beginning of that specific agreement. So we have Z will exist as a special legal entity. X and Y have come together. There are still X and Y as a result. And a new entity, which is now more than the initial two, has been created. And it is going to exist as a special legal entity. And it will usually have an element of control from both company X and Y. I hope we are still together on this point. Company X and Y are coming together through a JVA, forming company X and Y with a special new legal entity, Z, that is created, which is going to be controlled, or usually there will be an element of control from company X and Y as far as this new particular entity is concerned. Now, I hope we are still together, and the next key concept now you need to put at the back of your mind is what is provided for under Section 46 of the Competition Act of Kenya, specifically Part 4 of the Competition Act. You must have this at the back of your mind because it's very central as far as mergers are concerned. And this specific part of the Act provides whether a proposed merger is subject to notification and review by the authority. Remember, when companies want to merge and they submit their proposal, assuming it is a notifiable merger, the Competition Authority of Kenya has the discretion to approve that proposal, decline that proposal, or approve that proposal with conditions. Maybe a merger could be approved with conditions that once two companies merge, then employees should not be laid off. Because remember, people have to earn a living. And so when companies merge and they retrench all the employees, it destabilizes the economy. People have to survive. So this could be one of the conditions put. Maybe another condition could be that company A and B, you are allowed to merge, but when you merge company A, you should be able to sell off some of your assets. And the reason for doing this is that we are trying to reduce maybe you should sell off part of your business because we want to reduce sort of your dominance in the market. And also the concentration of power being in you as company A alone. So Section 46 becomes very central and you should refer to it at all times. And then the other thing we need to pay close attention to is Section 46(2). Remember that a merger could be approved, declined, or approved with conditions, but for this purpose, the authority must assess pursuant to Section 46(2). So under Section 46(2), these are the benchmarks that, this is the benchmark that CAK will be basing on to know whether it's going to approve, decline, or approve a merger with conditions. And so the other thing you need to note is that the authority will apply two tests. And one of them is the competition test and the public interest test in determining whether a merger is going to be approved, declined, or approved with conditions. If you look critically at the commercial transactions paper of 2022, there was a question on mergers, and there was an element of one company wanting to acquire two other companies and wipe out, I think, some of their shares. It wanted 100% ownership. So basically, this was leaning towards establishing a lot of market power concentrated in one company. And this may result into what we call concentration of power. And then this country will be in a position to control prices. It will be in a position to control suppliers. Such a transaction may not be accepted. I mean, such a proposal may not be accepted, or it might be approved with conditions. But remember, again, how you lay out your explanation, how you show your reasoning is how you're able to gather as much reward in terms of answering as possible. So basically, you look at Section 46 to look at the considerations, 46(2) considerations that are going to be taken into account. And then remember the competition and public interest tests that are going to be relied on by the Competition Authority of Kenya. Specifically now focusing on the competitive test, what we mean here is that we are going to be looking at both. Now, this competition or competitive test encompasses both the dominant test and the prevention or lessening of competition test. Now, we have for Section 46(2) outlining the reasons that are going to be relied on to know whether the merger is going to be accepted or declined or approved with conditions. And then we have the competition test being taken into consideration and the public interest test. Now, in terms of the competition test, we break it further into the dominant test and the prevention or lessening of competition test. Again, taking you back to the commercial transactions paper 2022, if you look at the competition test as far as that question was concerned, one company was likely to become dominant after acquiring the other two, and it was likely going to reduce competition in the market as far as that relevant market for manufacturing those specific goods that were mentioned was concerned. So this, to give you a bit of context, it was a 2022 commercial transactions paper, a question that touched on mergers. So basically, I think you can see the outlay and the reasoning that I've laid out as far as assessing mergers is concerned. Now, when we talk about the dominant test, we'll be looking specifically at section 23 and 24 of the Competition Act. These are critical sections in the Competition Act. And for purposes of this video, we are not going to be going so much into the detail of these sections. This is a full topic on its own. So understand how the dominant test is arrived at, and I'll be doing more videos again to explain the basics of that. So whether a merger will create strength or whether a merger is going to create or strengthen a dominant position held by one or more undertakings in a market in Kenya or a substantial part of Kenya. So CAK will be looking at such a scenario. And again, taking you back to the commercial transactions paper, the question on mergers, that company that wanted to acquire the other two companies, I think they were dealing in medical supplies, was likely to establish a dominant or strengthen a dominant position in the Kenyan market. And remember, if this can be depicted from the transaction, then CAK has the leeway to either decline that merger, accept the merger, or accept the merger with conditions attached. So I'm just outlining out, basically I'm laying out the tests that you need to know, but cutting down, there's so many words I could be using right now. I hope you see the reasoning from the tests that we described previously up to here. A closer look at sections 41 to 48 of the Competition Act of Kenya reveals a lot of things as far as mergers are concerned in the Kenyan context. And one of the key things you will note out of those sections is there are certain transactions that have to be notified. So the question is, who are you notifying? So if it comes to acquisitions of direct control, then you must notify the Competition Authority of Kenya to either get an approval or get an approval with conditions, or to have that transaction altogether declined based on the benchmark we provided, or rather discussed previously under section 46(2). So again, looking further into these sections, you're going to be able to appreciate mergers in the Kenyan context. But for purposes of this video, I want us to leave it at this, as I will be able to explain all those sections in more videos to come. Having appreciated what I've been able to share today, I want us to pay close attention to this final slide of this specific presentation. So anytime you're looking at mergers, please pay close attention to sections 41 to 48. Pay attention to section 46, particularly subsection 1 and 2. Pay attention to sections 23 and 24. Remember, when we are talking about the dominant test, these are the sections that speak to that. And then we have section 21 is also a critical section of the Act. And I've already emphasized how much you need to actually read and understand these specific sections. Remember, section a day will help you to appreciate this content, because mastering this content requires a lot of time and dedication. And then you can also look at the merger guidelines that are provided by the Competition Authority of Kenya. Read through them to appreciate the concepts there. And then look at also the COMESA rules on mergers and acquisitions. Basically here we're talking about mergers across Kenya and other countries within the COMESA region. And then please pay close attention to section 4 of the Competition Act of Kenya. It provides the language, the interpretation of specific words as far as this particular act is concerned. Words such as competition have a specific meaning, a competitor, a market. These are very critical words that you shouldn't take for granted. Remember, language is very paramount as far as mergers and acquisitions are concerned. This same section also outlines some of the main elements of the authority's merger analysis process. Basically, when CAK is analyzing the merger, it will also look at section 4 during that process of analyzing whether that merger is viable or not. And then there is another concept that I would want to introduce as far as mergers and acquisitions is concerned, but then this is a bit high level. Mergers, When we talk about the methods that businesses use to undertake acquisitions, we have things such as direct mergers, stroke statutory mergers. This means one and the same thing. Then we have asset purchase for cash and stock. And then we have asset purchase for cash and stock purchase for cash. Then we have other concepts such as the scope of successor liability. All these concepts you will be all these concepts you will be able to appreciate them further, but some of them are much appreciated at a master's level of specialization. And for purposes of this video, I want you to first appreciate the simple concepts, the simple sections in the Kenyan context, what a merger means, the basics of dominancy, the dominancy test, competition test, public interest test. So when you appreciate such concepts, you will be in a position to at least lay the foundation for appreciating mergers from a deeper level, an international level, and a more advanced level. Now, this brings us to the end of this video, and I hope you have picked out one thing or two. And if you analyze this today's discussion critically, then you can be able to actually fully attempt the question on mergers and acquisitions that appeared in the Commercial Transaction Paper 2022. Thank you for watching, and consider subscribing so that you receive notifications every single time I post a new video. And you can also make any comments below this video, and of course don't forget to give this video a thumbs up. Thank you. See you next time.